in what the topic is, but so it's
Okay.
collaborative practice and collaborative practice and mediation. So that's what the topic is going to be. So thank you very much for suggesting it, and thank you, Lisa, for coming in. And please, Mark, so just a short introduction. But I tell you what I'll do. I mean, you can just introduce yourself. What I have to do is, because in the neurodiversity and mediation session, Martha, who's autistic, I was asking her as to, in relation to mediation, yes, our sensitization. So I was asking her about my shows also, that if she watches it, anything that she wants to suggest in terms of maybe I'm going wrong somewhere. So she said, look, we need to be prepared as to what we are doing. So you should introduce what this is, the session is all about, because you know how I start abruptly. Okay, Mark, tell us about yourself and let's go. So what I'm going to be doing right now is I just what this is all about. Basically, this conference. Just give me a second to talk about that, Mark. After that, I'll let you people in. Just to
Yeah.
introduce yourself. So let me just introduce the what we are really here for. So basically, I've organized this World Mediators Conference. This is from 18th May to 30th June. The whole idea is to for us to discuss our mediation vision 2026 for the evolution of mediators and mediation. We'll have discussions on various topics, and then we'll continue that conversation, more elaborate conversation, as we go through the year. We started this on 18th May on Ken Cloke's birthday. I'm celebrating that as World Mediators Day, and I hope all of you will also is celebrated as that. And all the sessions of the conference are available on my YouTube channel. Just go to YouTube, search for Mediator Vikram, or Google Mediator Vikram. You'll get my website. Links are there, and you'll get the link of the schedule. All details are in that schedule. So that is what we are talking about. And Mark has suggested collaborative practice and mediation, which is a very relevant topic. And I mean, of course, we'll discuss it as we go along. So Mark is going to introduce himself, and then Lisa is going to introduce herself, and then we'll take the topic. Thank you, Mark. Please.
Thank you, Vic. Thank you very much. So my name is Mark Sabosley. I am an attorney practicing in Westport, Connecticut. And in order for me to introduce myself fully, I think what I'll do is reserve a little bit of my background for a description of what the topic will be, leading from my experience in mediation to my present practice as a collaborative practitioner. But as a preliminary introduction, I would note that I've been doing mediation since the 1980s, when it was first introduced into the Connecticut courts. And as a practicing lawyer, I've been involved in litigation, mediation, and now my practice is focused primarily upon collaborative practice. So I'll leave that for the time being, because I do have a little bit more detail on the origins of sort of my theories about certain things in the collaborative practice movement.
Perfect. So Lisa, do you want to just introduce yourself, and then we'll move forward on the topic?
Okay. So I'm Lisa Singh, and I have been practicing as a mediator, but mostly in community mediation. I'm not an attorney, but I think that in this topic of collaborative practice, I think I may have a creative way of looking at it, and I might add that perspective to the discussion. But first, I want to hear Mark.
Perfect. Mark, yes, everyone
Yes,
wants to hear you. Everyone wants to.
Okay, so I'm so happy that Lisa is here, because some of what I'm talking about today has to do with a sort of a specific focus within the family law arena, within the divorce arena. And I have some experience with community mediation. There's some very interesting contrasts between what happens in the practice of collaborative law or mediation in the family law arena, as opposed to perhaps in the community area where Lisa is practicing. So I'm really, really happy, Lisa, that you're here to add that dimension to this discussion. So if I could just, Vikram, when I first spoke with you, I noticed that one of the topics that was missing, so to speak, from the mediation sort of universe of topics that you've introduced is this idea of collaborative practice. And so I want to talk about the growth of collaborative practice and the expansion of it, but also the important subject, I think, is the role of the attorneys in the collaborative practice, and really very much in comparison to the roles of attorneys in mediation. So going back to my earliest origins with collaborative practice, I started out back in the late 70s, employed as an officer counselor within the Superior Court in Connecticut and the Family Court. And while I was there, just sort of as a matter of the way history sort of evolves, we started to do mediation for child custody matters. And our model was to bring in the two parents. We had a male and a female gender balanced mediation team. And then we would meet with the parents and we would talk about different options and so forth for the resolution of their disputes. And we did not have lawyers involved in those mediations. The other thing I did while I was working in the court was I did a lot of what we would call negotiations, where I would work with the lawyers to negotiate out different resolutions of the issues that were pending before the court. Another job that I had, which I think is particularly important for my point that I'm going to make, is that I was also an evaluator. And in the capacity of an evaluator, I was basically a judge. I would do a full study, evaluation, and so forth, and give a recommendation to the court regarding where the children should live. And one of the most important takeaways for me that has lasted with me for the past over 40 years is that I've really identified the law and lawyering as a judgment profession. And the role of mediators, therapists, and others, for example, Lisa in the community mediation world, as a helping profession. And that distinction has carried forward for me for many, many years. There's this difference between the judgment professionals and the helping professionals. And, you know, as an evaluator, if I was doing a study and I was going to talk to the therapist for one or both of the parents, I would discount what that therapist had to say because I thought, well, they were automatically aligned with their individual clients and so forth. So that gives you a sense of how people can actually be discounted or even disregarded when it comes to judgment. So fast forward into my career as a lawyer, after I got out of that job and I've finished my law school training while I was doing that job, I have represented clients in mediation, whether they were court connected, where a mediator was appointed by the court as a special master, or I've represented clients with mediators who were retired judges. And I've also worked as a private mediator in my own practice of mediation, including volunteering as a special master with the courts. And as I mentioned before, I've been involved in community mediation for a period of time. And perhaps equally importantly, over the past over 30 years, I've created a course for law students to try to assemble all of these different principles and theories and practices under the umbrella of alternative dispute resolution. And I teach a course, it's a 2-credit course at a law school in the subject of alternative dispute resolution. And lately, within the past, I'd say a couple of years, I've added collaborative practice to that curriculum. Collaborative practice has been around for a while. It started in the 1990s, but it has taken a while for me personally to become sufficiently acclimated to the practice to feel comfortable about bringing it into my curriculum. And now that I have, and I've actually made this significant transition into the practice of collaborative law, what I thought it would be helpful is if I could sort of talk about some of the differences between mediation and collaborative law, collaborative practice. And so having added it to my ADR curriculum, one thing I would note is that when you try to teach law students about mediation, you encounter this morass of theories and practices and principles to the extent that one author, Leonard Riskin, has written a couple of different articles that are entitled A Grid for the Perplexed and a Revised Grid for the Perplexed, because what he's trying to do is assemble all of the different approaches to mediation under one umbrella, try to make some sense out of it. And I'm not completely sure that that's possible because mediation is so expansive and so potentially creative in its infinite potential that I don't know that you can really put it into a box or put it into any particular formula. So what is important about this is that mediation is really very much the orientation of the collaborative practitioner. So there's various standards and ethics and protocols for collaborative practice that have been developed since the 1990s. And some of those standards and practices are very, very similar to what you would see when you look at the types of practices that mediators engage in. And so, for example, a mediator will try to demonstrate reflective listening, empathy, compassion, and all of those traits that many, many of the speakers in these symposiums have talked about. Those are very much the same traits that a collaborative practitioner will seek to demonstrate and to emulate. The idea of collaborative practice is essentially the same as the idea of mediation, in that we are trying to empower the clients to make their own decisions. And in any way that we could empower the clients and respecting the fundamental principle of self-determination, which is also essential to mediation, that is what is required of every collaborative practitioner. So as a lawyer, the idea is to really make a shift. And I don't know if, Vikram, if you've heard of this concept before, but it's well known within the collaborative community that lawyers and other professionals are expected to make what's called a paradigm shift. That paradigm shift is toward something that looks like a mediation paradigm. It's toward the paradigm where the lawyer becomes a helping professional. The lawyer is no longer a judgment professional. The lawyer doesn't necessarily come in with the adversarial advocacy orientation that you would normally have if you were going to court, or in any other context, if you were going into a court-connected mediation. Typically, what happens between lawyers is that one's prediction of the results of a court hearing competes with the other's prediction of what the results of that court hearing would be. So everything is happening within that judgment paradigm because we are all looking toward the point where some authority, some judge or tribunal will make the decision. That is so far from what happens in collaborative practice that people don't truly understand how significant that change is. However, the beginning point where people start to begin to understand the significance of that is when we realize that we have to enter into, as part of the collaborative process, we enter into a written agreement. Both lawyers, both clients, and any other allied professionals sign an agreement that if we don't succeed to resolve this case by agreement, we are then disqualified from proceeding further in any legal proceeding. Now, the significance of that is that when we get into a difficult situation within the negotiation, within the case, we can't just threaten that we're going to go to court to get a better result. As a matter of fact, threatening to go to court to get a better result is actually something that we say is prohibited. If you have made that collaborative paradigm shift, you can't go into the collaborative meeting room and start talking about what you're going to do if somebody doesn't meet your expectations or comply with what you think is the quote unquote best result. So if you compare that engagement between lawyers with the type of engagement between lawyers that I just described, where the competition is between what I think the court's going to do or what the other side thinks the court's going to do, we set all that aside because what the court is going to do is irrelevant. We're not going to court, and we've agreed in advance that if the case is going to go to court, we're not going. The door is closed. And, you know, this is one of the most fundamentally important points that I make to my law students. Even in mediation, as well-intentioned as the mediator may be, if you have two representatives of the parties, two lawyers, who are seeking to obtain a particular result. It doesn't really matter what the mediator wants to try to do. If those lawyers are going to come in, they can obstruct the process. And I'm not necessarily saying this as a way of denigrating the role of lawyers. I think that the role of lawyers is very important in the context where those lawyers are expected to advocate in that particular way. However, when you get into the collaborative process, if you have signed on to that collaborative participation agreement, you have agreed that you're going to engage in interest-based negotiations. They're going to be based on good faith, full transparency, and you're not going to be using threats of litigation or threats of a different result or threats of a better result at trial in order to get some sort of either advantage or to coerce or put pressure on people to come to your particular version of what would be the right result in a particular case. So that's kind of the overview of the difference between the sort of role of an attorney in mediation and the role of an attorney who's practicing in the collaborative paradigm. As I said earlier, when I first made this distinction between the judgment professionals and the helping professionals, I didn't realize how essential it would be to my present understanding of my own role as a helping professional, because I can't define myself as a judgment professional when I'm doing collaborative practice. I define myself as a helping professional. And so when I take all of those ideas, all of the practices, all of the theories and models and principles and so forth of people in the helping professions into my own work, then I become a better practitioner. And in order for me to maybe make this point a little further, let me just spend a minute on the idea of the collaborative team model. So I mentioned that we enter into a participation agreement and that the lawyer is expected to practice according to a particular collaborative paradigm and make all the shifts associated with that paradigm. However, we also engage with other professionals in the practice. So typically, and again, if we're talking about a family law case, typically there's going to be a neutral financial professional. There will be a neutral mental health professional. Sometimes there will be allied coaches for each of the clients. And sometimes there will be a specific mental health professional who will be designated as a child specialist. The team works together, and the team is all participating in the ultimate result of empowering the clients, helping them to come to results that achieve their best and highest goals, help them achieve their needs, help them identify their needs, help them identify their values and their interests. And so when you're working in a team, it is now a whole new challenge. It's a whole new opportunity, because I, as a lawyer, see a particular client. I see a particular constellation of ideas or interests or values from that client. If I'm working with a team member looking at that same client, I'll guarantee you that that person coming in from another professional discipline perspective will see a different client. They will see specific aspects of that client that are more, they will enrich my view of my own client. They will enrich my view of the relationships between the parties, the relationships between the parties and their attorneys within the room. And sometimes the mental health facilitator, who's a neutral, will help to smooth over some edges that might become a little rough within the context of the collaborative process. The financial professional is also a neutral, and the value of that particular person is that that person will gather information from the various parties from both sides, and will collect that information together to put it together in certain reports related to income, related to assets and liabilities. And the most important part of that is that if each lawyer is in a separate camp, gathering the separate information and evaluating that information separately, oftentimes people begin the negotiations from a positional place. often in the typical representation of a client, let's say in a court proceeding like a special master's mediation or a court-connected mediation, the rules actually require that you come into that mediation having prepared your written demands, your written claims for relief, your written proposed orders. When you have to put together the written demands that you're going to make, you are entrenching yourself in a position from the start so that both sides come into that negotiation with each other. And even if it's a mediation, you're already coming in entrenched in positions. And the poor mediator then has to start untangling and unwinding and loosening the people's grip on what they think is the best result. So when you do the collaborative work and you assign to the financial professional the task of gathering the information, sorting it out, putting it together in reports that are coming from a neutral perspective, you have a greater likelihood that everybody is seeing the same case from the perspective of the neutral, which is really a matter of just gathering facts. And as you may know, Vikram, from being an attorney and for everybody else who has ever done any amount of litigation work, just the idea of gathering facts alone, people disagree about whether it's day or night. They disagree on things that shouldn't be disagreed upon. And when you elevate that to a level where people are disagreeing upon the basic facts, there's very little hope that you're going to resolve the case, because most likely you're talking about two different cases. So the idea of the neutral and the collaborative process is to help us to start from a point where we are looking at the same case. Sure, we could disagree about values. Maybe there's a closely held corporation or a piece of property or something else that would require us to look at a fact that might need to have a little more of an evaluative approach to it. But for the most part, the system is not designed to start with a handicap where people are entrenched in positions. The system is designed to start with the help of other neutral, collaboratively trained professionals who are all participating in the same ultimate objective on behalf of these clients and this family. And so the thing that I think is that I wanted to bring into this discussion, Vikram, with the multiple enormously talented people that you've brought in to talk about mediation, is this idea of collaborative law, which actually some people say stands on the shoulders of mediation. You know, collaborative law, being that it came along, let's say in the 90s, we had been doing mediation, and Lisa will certainly attest to this, for many, many years before that. So collaborative practice really sort of does stand on the shoulders of mediation. It sort of, you know, I would wonder if collaborative practice would be where it is today without the culture of mediation. You know, that's another point about the culture that I wanted to talk about. What has happened within the collaborative community is that early on, there was an association established called the International Academy of Collaborative Professionals, IACP. IACP now has members in, I'd say, more than 20, perhaps between 20 and 30 different countries throughout the world. And there's a forum that's coming up this October. They have a learning and networking forum every year. People come from all around the world to participate. And the fascinating thing is that when you see the people from Australia and from Argentina and from Ireland and from Spain and Italy are talking about mediation as they are in this forum that you've created, Vikram, the collaborative forum is a very similar community that is designed to enhance and promote collaborative practice. So what you find is enormous training opportunities by extremely talented people who are talking about many of the things that a lot of the presenters in this forum and these symposiums have been talking about, because of that synergy, that sort of simpatico between the work of the mediator and the work of the collaborative professional, those essential ingredients, whether you call it compassionate listening or you call it empathetic communication, or if you look at things like Henry Yampolsky's talking about dissolving conflict from within, or the things that Michael Lang and Safnat Peleg-Banker are talking about, the idea of reflective practice. You know, in the built into the protocols within the collaborative practice, after every group meeting that we have, and everything is basically done within a larger, group meetings with the clients, we will have a debriefing session. And that debriefing session is very similar to what Michael Lang and Safnat Peleg-Banker have been talking about in terms of reflective practice, the idea of having reflective practice indicators. I find that to be fascinating that they are working on those, because in the collaborative world, we are talking about improving our practices by listening to where our colleagues saw that maybe I made a misstep in a particular session. Maybe I slipped back into my, lawyer mode, or maybe one of the other participants might have done something that set this off on perhaps a different track than we wanted to go. We've got to be open to each other as collaborative professionals. And one of the things that is developing within the collaborative community is this sense that we learn from each other in each case. Pauline Tesler, who is one of the most distinguished and well-regarded trainers and authors in this area, has written many, many wonderful articles, written several books. And she talks about the collaborative team as an emergent learning system. Within each team, within each case, we are learning how to be better practitioners. And within our practice groups, so here in Connecticut, where I am in a small segment of the state of Connecticut, I've got two different practice groups. One has perhaps between 20 and 30 members, and the other has a little more closer to 20 members. There are other practice groups within the state. There are practice groups throughout the country. And in fact, I'm part of the practice group development committee of IACP, which deals with practice groups throughout the world. So the idea of the practice group is to continue to cultivate those skills, cultivate those appreciations for the work of the others. If I go into a collaborative meeting and I think because I'm a lawyer, I'm going to be in control as I normally would if I was trying to do something in a court situation, people are going to call me on that. I'm not in control. It's not about me being in control of anything. It's about me being able to facilitate the process and to be an advocate for my client, which is defined in a different way. The interesting thing about collaborative practice is that each client has their own attorney. That is one of the distinctions that sometimes we find with mediation, where people often don't have representation in a mediation. In the collaborative process, a collaborative case is defined as each party having their own collaboratively trained attorney. And one of the things that I think, Vikram, when we first spoke, I think I might have complained to you, a sort of recurring complaint that I've had, that as long as I've been teaching about mediation and teaching about the theories and the multiple approaches and so forth, I've often found that those theories are talking to the people who own the dispute. Let's say if it's a husband and a wife or a mother and a father, the parents of the children, they own the dispute. But when you get involved with representatives who don't own the dispute, but who are involved in the dispute because they are being hired and paid and they are doing their best ethical jobs at representing their clients, oftentimes the theorists don't really speak to those representatives. And so when you have representatives in the collaborative process, as opposed to representatives in mediation who are essentially free to negotiate, as I said before, in any way they want, and they can, including saying, well, the heck with this, I'm just going to go to court. When you have a representative in the collaborative process who's collaboratively trained, then you really have that sort of that system in place. You're not going to be using the threats and so forth that might happen. And the idea of a lot of the theories about interest-based negotiation can then be taken to heart, perhaps more so by the lawyers representing the clients in the collaborative process. I know for sure from many of my law students that they're very, very deeply devoted to non-adversarial practices like mediation. But as I say, maybe the next generation of lawyers will be a little more capable and flexible. But when you have established lawyers, established practitioners who've spent many years, as I have, representing clients in an adversarial process, it takes quite a shift in your attitudes and your actual beliefs and practices to be able to be effective as a collaborative practitioner. So what I've been doing lately is I'll participate in year-long study groups. I'm finishing up one that's this coming month will be the 12th month of a 12-month study group with people from around the country. I've done that also with several other people guiding the study group. This particular group I'm talking about was guided and coordinated by Pauline Tesler. There's some very prominent other mediation and collaborative professionals like Woody Moston and Ron Oski, who've put together another one that I participated in for a year. And this is what is driving me as a collaborative practitioner. It's the energy of learning, the energy of expanding what I can do, how I can be effective, how I can be better at what I do. And in order for me, I was so taken by Gabriela Asmar that I wrote to her, and I wanted to find out more about the constellation process. And I was so taken by the way that she made one comment. She said, your judgment is your blindness. To me, that says it all. Because if I come in and I'm prejudging as a lawyer before I even start the process, I'm blinding myself. And one of the reasons why I really love the fact, Lisa, that you're here is that I listened to your presentation and I was so thrilled to listen to how you approach your mediations with such openness and such receptivity and such empathy. I'm just learning, to chip away at some of the old blocks of my own habits, because I can't hold on to those things anymore. I can't find security in the business of being some, pardon my words, but hard-ass lawyer, hard-ass litigator. I've got to be able to be more effective at being a human being, as well as being a constructive participant in these processes. And so, I've spoken a lot about how collaborative practice has fit for the family law matters. There is also a movement toward incorporating collaborative practice in other areas, not just in family law, things like matters of estate, wills and estates and trusts, and matters when let's say an elder parent dies or whatever, and there has to be a resolution, or maybe even in a family business transfer of ownership from one generation to the other. Collaborative practice is really designed for those cases where a relationship is an important part of what the individuals involved are concerned about. So of course, family relations is one of those. I guess one other point that I would make before I stop and maybe open up the discussion is that as many theories and models as I've studied, some of those theories that I think are the most suited to what I'm talking about here are like the transformative types of theories. And the interest-based is a little bit, it's sort of thrown around a lot in our discussions. It's clearly the important way of negotiating, certainly not from positions, but also from an interest. But, the transformative approach offers, I think, this sort of a sense of a higher ideal. So much of what we try to do as collaborative practitioners at the very beginning of a case is to establish what are your goals and your highest ideals for yourself, for your children, even for the other participant, so that we could start on a positive footing from a higher place, and maybe at times go back to remind the parties that that's where they started from. So I think that pretty much covers my initial spiel. I could go on obviously for 2 more hours, but I want to actually stay true to our idea of keeping a dialogue going. So I'll stop here and see where maybe this leads.
Yeah, because basically the idea was that we start the conversation in the conference and then we take this up later, because obviously this is a topic which has to be discussed. And when I hear you, Mark, this is the way the legal profession was supposed to be practiced. It might have been taken in a certain direction by people. It doesn't mean that was the right way to go. So it'll have to come back to this exactly the way whatever you're talking about, because that's the way I practiced, and it's never been an issue. Even in adversarial aspect, you said, look, we move when it comes to the to litigation, we don't go there. But I'm saying even in the adversarial part of it, there also, how I look at it is at a lawyer with a mediator mindset. That's what you are. So a person who's a lawyer with a mediator mindset, of course, doesn't want to go into litigation. But even when you are part of litigation, if you go in with a mediator mindset, if you're representing anyone, you're reaching out to the other side, and them also understanding that, you look here, it's not a fight, we're trying to resolve something. So that mindset should stay with you wherever you go. So I'm saying that collaborative practitioners are those lawyers with a mediator mindset who don't want to practice as mediators, but they still want to be part of the mediation process to a certain extent, and they take those whatever those skills that they have into their practice as lawyers. So I'm looking at it from that point of view. But the other thing was, of course, I'm very happy, Mark, that you are at least watching some of my shows. At least someone in the world does that. I'm so happy. So I mean, if you've quoted all these people, I assume that you've actually seen all those properly. So they're all wonderful people, such nice conversations. So I think that's a nice thing when you hear someone actually seeing it. But I think, look, the thing is, we moved away from interest-based negotiation. Now we're into value-based negotiations. So that's the one that we are going to be talking about a lot about, and it's come out in the Heart Soul Spirituality Symposium also, that aspect of it. So that's how we would be looking at it from, because that is an area of again, that's the way it should have been practiced, and maybe we moved away from it. So we go back to that. Let's bring Lisa in because she's waiting to come in. Yes, Lisa, please.
So yeah, Mark, that was so interesting, and I like the way that you analyzed it. It was really interesting. So a little bit about some of the things I was thinking about, because in my experience, I've done divorce mediation. I do that privately, as well as I did it actually for the county as part of the court. They sort of assigned us mediation. And I've done child protection. We call it child protection, but it's really about custody issues in the juvenile court. And I did that actually as part of the court and part of the mediation center. I think, what we noticed, we would have attorneys come into the mediation with the parties, and we would mediate that transformative mediation, since you said you like it. We would mediate it, and we had attorneys come in like, I don't like this, I don't like the process at all, but they would leave really satisfied with how it turned out. And so we also noticed that attorneys who were resistant to the idea, once they experienced it, it changed their thinking. And we have a collaboration also with the law school, University of Dayton Law School, and the Dayton Mediation Center does, not me. But we've had that collaboration for years as well. We train a lot of the law students in mediation over the years. And I think that distinction, and I look at it as collaboration can also be done with collaborating with community mediation centers or mediators, because there are some attorneys who like to do that, even if they're not collaborative lawyers or don't want to mediate themselves. They use mediators in their practice. I have a couple of attorneys I work with. They don't want to mediate, but they do like to use mediators. And so that's another way of, I think, thinking about the same approach. And I don't know, I like it only because I think the ultimate goal is the same. What do you want as the best outcome for your client? And what's going to give the best outcome for the client is the way of thinking of it. Whether you approach it from a judgment point or from, as you were saying, at a helping point, it's what's going to help us get there and what's going to be a more long-lasting and sustainable result. So one of the things I've always loved about mediation that I've done in divorce cases is that I noticed that maybe it's, I don't have statistics, but I think there are some statistics out there that show that there's a lot less conflict between the parties when they've had a good mediation, and that they have a better result, particularly for the children, because they're not fighting over the children. And so to me, that's a better outcome. It's better for society as well. I think some of the restorative justice techniques, not just mediation, should be included in that, because I think in Minnesota, they did wonderful things with circles, and that lends itself to practices other than just family or a relationship orientation, because criminal law works well with circles. And so thinking of that, and again, to me, it's about what is the best result, that we have for not even just the clients, but for our society as a whole. How can we help have a more holistic and satisfied, a result for everyone? So that's it. I'm done.
That's it, Lisa. That's very surprising. I thought we have to skip the next session. Okay, so
if you'll ask me questions, I'll think of something else.
No, I think Mark, basically I just look at it from this perspective. Like I said, let's bring lawyers who have the mediator mindset, bring them out, let people, even parties, clients also should know that this is also an option available. And these people are going to, even if they're going into litigation, they are going to go with the mindset is not what is best for you. That's not what you keep telling your client. You have to see what is the best way to resolve the dispute, because if there is a certain way of practicing mediation, say in the US, which say no, you're only supposed to be facilitative, the mediator, but the lawyer doesn't have to be. The lawyer can be looking at the larger picture. And that is where the collaboration has to come in, not just with of course, you're collaborating with your client, but also collaborating with the other party. There's nothing wrong with that part of it, because I'm saying that there have been times when the other party has had, as when I've been practicing as a lawyer, now it's only as a mediator, but the other party has had so much trust in me, they've brought me in as a mediator. Can you imagine? This is a litigation going on. So it is just that approach towards the entire process has to be such that you bring out that aspect that here we're trying to resolve it. We're not trying to push it into a long-term, long-drawn battle. So the approach of the individual, and I feel that that approach is something that the people who have it, I think we need to bring them out.
Vikram, one of the things that you just mentioned, the word trust, is one word that we have been focusing on a lot in the collaborative community. And as I mentioned, we have practice groups. A large part of that work of our practice groups is to help us to get to know each other so that we could trust our other collaborative counterparts. If I go into a meeting with a collaborative case, I can trust the others in the group on that team, that they're going to be doing essentially the same things that I'm going to be doing, as Lisa said, to try to get the best results we can. The one thing that's the distinguishing feature, and I love your point, Vikram, about how you could go into even a litigation with a mediator mindset. The one thing that distinguishes the collaborative practice is that agreement that we sign in the beginning. And it's a structural component that defines the collaborative case. I agree with you that there are many, many capable lawyers who could go in with the mediator mindset, but when you add that ingredient of that signed collaborative participation agreement, it really defines this container really that we create for the clients. We try to create this safe container where people are trusting each other, the professionals are trusting each other, the clients can see that there isn't that level of animosity involved. And within that container, the clients can then hopefully become a little more empowered. As Bush and Folger would say, when people are in conflict, neurologically, they're often incapable of doing anything except trying to protect themselves. And if we try to empower them the theory is that the more that they can become empowered, the more that they could possibly recognize what's on the other side of the case. So what we're trying to do is create that safe container, and the collaborative written agreement that we have, that contract that we sign, is an essential part of that as a matter of a system design. And so that's the only distinction I would make, that I think would be very important for people to consider looking at collaborative practice separate and apart from the other models that we've talked about. That really does define the collaborative case, that collaborative participation agreement. I particularly appreciate, Lisa, your point about restorative justice and circle groups and so forth, because there are so many wonderful practices that can help people to perhaps feel, the ability perhaps to express themselves. And that safe container idea is one. The other thing that you mentioned that I think is extremely important is that idea of that durable agreement. It's one thing to go into, a negotiation with cooperative lawyers who are, friendly negotiators or whatever. They're going to settle the case and they're going to finish the case and the case will be done. They could sign their names and everything can go away. But those durable agreements, the ones that are lasting, are the ones, as Lisa, you're talking about, are the ones that we're trying to create with a group that helps the people to really get to what Vikram's referring to as the values and get to their underlying deepest needs. Speaking in terms of needs, how people at some level all share similar needs. Well, we really try to allow people to build their agreements in a more durable, lasting way, so that you don't have repeat, returns to court over issues. But and sometimes a byproduct of this process is that the parties learn how to communicate better or differently with each other than they did when they started out. And so, that's one of the things that I think, I'm sure.
And I think, we definitely. And I think also people forget sometimes the relationship is important. And a lot of times what they ask for in the beginning is not what they want in the end. They want to retain some part of the relationship, and so, I mean, that we talk about interest as the interest of the parties in terms of interest based, but sometimes the relationship is in the interest of the parties. And we watch that transformation sometimes when they settled it themselves and they saved the relationship somewhat. So that means that was there on the table, but we didn't recognize it.
No, I think that's basically, Lisa, here what we'll do is, of course, that is what happens in a mediation. But here, what in terms of the collaborative practice, what I'm thinking, Mark, is that in terms of the way, say, the practice of law, so the position-based, interest-based, value-based, I think the practice of law will follow the same, should follow the same thing. But it's only going to happen when people recognize that this is a good thing for us, rather than someone else. I mean, talking about it sounds very nice, but when people understand themselves, they look for lawyers like that. And how does that happen, Mark? How do we take that forward?
Well, there's quite a bit of work being done within the collaborative community to promote collaborative practice. The more cases that we are seeing here, the more successes we have, there's that many more people who are seeing and becoming interested in it. And, collaborative processes are also benefiting from the amount of exposure of mediation principles. So, I think that certainly in the United States, in this area, mediation is pretty well known. And it's just a question of, whether the parties are able to choose one process or the other. And Vikram, I think one of the questions that I encountered when I was involved with community mediation here, and I know that we're going to have another session and the symposium on this subject coming up, I guess, in a week. But the thing that I learned when I was involved in a local community mediation organization, but we were offering free services to resolve people's disputes. And the only cases we could really rely upon were the ones who came through the court system. So for whatever reason, there still is a fixed kind of systemic view that
that's a discussion that's a discussion by itself, which we are doing. The court system, you were not part of that. We had a discussion on mediation in the court system. Boone O'Bain, Julie Fields, he has retired as a judge in the US. She was talking about her experience because she's a mediator who went and was on the bench, so that experience. But what I was saying was, how do we get Hollywood to make movies with collaborative lawyers? How do we do that? When is that going to happen? Because that that is where people will understand that option is also available. So when does that happen, Mark? How are you working towards that?
I was trying to remember the scene in it was I'm not sure if the movie was called The Marriage Story, but there was a scene actually where they tried to engage in a negotiated collaborative process. Well, I think that there really is a need for the public to be more aware. I think it's a tall order for me sitting here in a small town in Connecticut to think about what might be happening in Hollywood.
No, Mark, no. Everyone is important, and they have their way of going about it. However, they're going to influence it.
Yeah. Well, I think that this symposium series, Vikram, that you've put together is certainly a step in the right direction.
I tell you what, Mark, let's call it the conference. Only for me. Just call it the conference instead of the symposium, because I've done a lot of symposia. Now it's the conference.
Right. Yeah. So the conference is a big step forward, and we should have more of these. And it is part of the work of the International Academy of Collaborative Practitioners to do outreach and do as much as we can to educate the public. A lot of what we're doing here in my practice groups is we're talking about how we can improve the public's awareness and education of collaborative processes. And that is an ongoing effort. It'll be an ongoing effort for quite a while because, the system that we are up against, the inertia, is that people typically operate from fear. And because people are operating from fear, they're looking for people to represent them, to protect them, when fear may be a valuable sort of expression of something else that doesn't need to be protected as much as sort of expressed, so that people in a collaborative or mediation context can understand what's driving that fear and how to address those fears. But we are up against that natural tendency of people who are in fear, afraid of what the future is going to bring. Maybe their neighbors, their friends, or their relatives say, well, you have to go get this very strong lawyer advocate because they've heard that this is a very capable professional person who can protect them. Well, that's okay. But the fact is that it's unfortunate because, if people were willing to take the chance of sitting down with a bunch of professionals who are all signed on to accomplish the best possible results they could get, as Lisa says, the most durable results, then that would be a much better option for people. And so it's taking time, and I understand that.
Because then you're looking at it a little differently. Of course, you said you need a lawyer who is going to protect you, and you go to such a person. The same thing happened with courts also. The courts were supposed to be places which would protect you and your rights and whatever, but they were not successful in doing it. That's why they're pushing people into mediation. So in that sense, I don't think there is any issue in telling people about the fact that lawyers are supposed to be like this. They're supposed to be collaborative. And let's not talk about it as some new thing that we're talking about. We should talk about this as the way to practice law. The other thing is an anomaly, not this. So it's gone in the wrong direction. We are trying to get it back to what it's supposed to be, the noble profession. That's, I think, the way the communication, the way it goes out. Suppose you start thinking that you're on your back foot or something like that. I don't think so. I think it's a matter of pushing it aggressively telling people about it, that it's gone in a direction which definitely was not the way it's supposed to go. And in a confident way. I mean, I still feel that people sometimes are little, I don't know, I mean, not being able to push it the way they should be pushed. I still feel that.
Well, I definitely agree with that. In fact, I had a guest in my class last semester from Canada, who is a very, very capable professional, collaborative professional. And I mentioned while he was on Zoom from Canada, and I had some other people on Zoom in my class here in Connecticut, and I mentioned the title of my course, Alternative Dispute Resolution. And my friend Chris Arnold said, I'm not alternative to anything.
Exactly. Okay, but I'll get Lily in later. Lily will say hi to you later in the next session because she's come a little early for the next session. But you can later, you can tell, because you don't have too much time. You have 3-4 minutes to just conclude. So conclusion is, Mark, we have to do another session, a proper, in part of the conference. I don't think we'll do it later after the conference because we've got the little discussion going. Let's do a proper, I don't know how we're going to do it, as a session or a regular kind of thing, because this is something we need to put across the mediator mindset in lawyers, that the legal profession to be practiced in such a manner, which definitely helps mediation also, because if that is the mindset that people go in, obviously that also helps. So if there is, what we'll do is we'll ask Lisa to give her little concluding remarks, and then you come to you, and then we'll conclude it, because she hasn't been able to speak because I kind of cut her off. Yes, Lisa, I cut you off. You were saying something. But you'll have to unmute yourself. That part of it, we don't have too much time.
No, it's fine. It's fine. I mean, I think that the idea, I like this idea of this mediator mindset and practicing that way. I love that. But I also think that consider that if you don't want to mediate, have the same mindset that handed to, people who mediate, and collaborate with them as well. Because I'm all for collaboration in any form, in any way, because like you said, Mark, I love the way that you said it too, is that all those different perspectives help to bring out, sides and facets that we didn't see.
But I tell you, Lisa, the thing is that, because that's the way I practice as a lawyer, collaborative. Because there's so many examples I can give, which we'll take up in the next thing. But there's so many examples where the other side trusts you enough that you are helping them draft the language of a contract. I mean, you are on the other side, you're representing someone. So these are things which actually, if it's not been done in that manner, people think, oh, this can't happen. That's the way it should happen. So Mark, a little concluding kind of thing, and then we close the session because we have to start the next one. So please.
Okay. Well, thank you, Vikram. I'm so happy that I was able to bring in the collaborative perspective to your discussion of mediation. And I do think one concluding point is that when we talk about collaboration, we talk about an inherent dependency on the performance of our colleagues for a lawyer or another professional to do excellent collaborative work. And I like that idea, the idea that we depend on each other as colleagues to do excellent work. That is something that I think is a really valuable part of the collaborative process that has me plugged into this. And I'm basically doing it now as a full-time practice.
Yeah, well, because I have 30 seconds to conclude. This is what I'm saying. In an arbitration, if the other party, I'm representing a client, the other party has that much trust that we sit in a mediation and they do not bring their lawyers into it. They have that much trust in you. That's the collaborative kind of atmosphere that you have to create. And that's where lawyers were supposed to, that's what they were supposed to do. So thank you very much, Mark. And of course, you're coming in again on lots of sessions. You're coming in for the family mediation, a cultural perspective, and also community mediation, a US perspective. Right. So a US experience. So, and Lisa is also coming for that. So we'll see you there. And thank you very much. You can stay in the next session. I mean, totally your wish. I'll just cut the live stream here. Thank you, Lisa.